The European Court of Human Rights is a supranational court established within the framework of the Council of Europe. Its mission is to ensure the respect for the International Convention of Human Rights and Fundamental Freedoms adopted in 1950. The court has judged numerous cases of surrogacy. It tends to force states to recognize filiation established abroad in execution of surrogacy contracts, in other words, to give effect on their territory to a contract of surrogacy, yet illicit in the domestic legislation. So, we often hear an objection. Any attempt by a state to fight against surrogacy would come up against the jurisprudence of the European Court, and the state would have to give up. I don't agree, and I will now explain why. The facts are generally as follows. Citizens of a state prohibiting surrogacy go abroad to a country where surrogacy is legal to obtain a child from a surrogate mother. The childbirth certificate, established in his country of birth, indicates the orderers as parents. The intended parents ask their own country to recognize the filiation thus established abroad. The European Court first said that states must recognize the filiation with regard to the orderer who is also the biological father. Then, the court affirms, in a 2019 legal opinion, that the respect of the privacy of the child demands that domestic law offers a possibility for recognition of a filiation link between the child and the intended mother, named as a legal mother in the foreign birth certificate. This solution also applies when the intended parent is a second man. But this is not the end of the story. First, the European Court itself validates other solutions. For example, in an Icelandic case judged in 2021, two women use surrogacy in the United States and are listed as mothers on the child's birth certificate. But Iceland refuses to recognize these women as parents. Upon arrival in Iceland, the child is considered as an unaccompanied minor. The authorities appoint a guardian for the child and place him with the two women acting as foster family. The European Court validates the state refusal to recognize the intended parents as parents. You may note that it would also have been possible to appoint the two women as guardians. This decision shows that it is possible to take the factual situation into account without validating the surrogacy process in order not to support the violation of children's rights resulting from surrogacy and not to encourage people to have recourse to it. In two cases judged in 2022, the court even validates the refusal by England and France to establish the paternity of the man orderer of the surrogacy, even though he is the biological father. In the English case, a conflict opposes the orderers, two men, and the surrogate mother and her husband, recognized as parents of the child under the British law. In the French case, a woman concludes an illegal surrogacy with two men for 15,000 euros. Then she claims to the biological father that the child is dead, and she sells she sells the child to another couple, again for 50,000 euros. The English and French courts, faced with this imbroglio of filiation, refused to establish the paternity of the biological father who has ordered the child. The European Court validates. These cases are different because there is no filiation here already established abroad. Surrogacy was practiced in the country itself, legally in England and illegally in France. But the European Court accepts that the interest of the child can even justify rejecting the claim of the orderer of surrogacy, even though he is the biological father. Next, by forcing states to recognize filiations established abroad in execution of surrogacy, the court contradicts its own principle. For the court, indeed, the respect for privacy includes not only the right of each person to know one's origins, but also the right to legal recognition of one's parentage. However, when it's about surrogacy, the court assimilates the filiation of the child to the filiation agreed between adults by contract. The court pretends to impose recognition of the child's parentage, but it imposes recognition of its deprivation. The child has the right, guaranteed by the UN International Convention on the Rights of the Child, to know his parents and be raised by them. What remains of this right if it is redefined as the right to know and be raised by those who have decided to be his parents by contract? States could better argue and require the court to respect its own principles and the content that itself gives to privacy. Next, the European Court considers the Convention as a living instrument, which must be interpreted in the light of today's condition. The Court assumes the power to adapt the Convention to changing morals. It considers that finding a consensus can replace an explicit international commitment by states and, decision after decision, relevant principle decreed by the court itself augment the text of the Convention. Regarding surrogacy, the court notes in each decision that there is no European consensus. Despite this, it does not hesitate to set out very precise demands on states. There is no separation of powers here, and the problem of democratic legitimacy, because European judges are not elected, have not received any mandate to enact binding rules for states of the Council of Europe. We are witnessing a drift in law. Human rights, in this case privacy, serve as a pretext to force states to turn the blind eye to the violations of human rights by surrogacy. The best interest of the child serves as a pretext to turn the blind eye to the violation of the rights of the child. States should not accept such dysfunctions. Why don't they appeal of these convictions, to thus making themselves complicit in the surrogacy suffered by the child? Only one country has appealed against convictions in matter of surrogacy, Italy. Thank you, Italy. This resulted in the only decision ended by the Grand Chamber in 2017. In this case, Italy decides to withdraw from the orderers custody of a child illegally obtained by surrogate mother in Russia, and to place the child for adoption. The European Court initially condemns Italy, but the Italian government appeals, and 2 years later, the court, meeting in the Grand Chamber, validates the decision of Italy. States are the men responsible for the application of their law and the protection of their population. They could appeal these convictions and claim their right to have human rights respected at home. In conclusion, seeking solutions for children born through surrogacy is good, of course, but it is compatible with the fight against surrogacy. Why oppose these two actions? Au contraire, they are complementary. Since states can see there is not satisfactory solution once a child is born through surrogacy, states have to take legal action to discourage surrogacy. And furthermore, the court is only involved in the parentage of the child born through surrogacy, but states can act to prevent surrogacy by preventing agencies from offering their services and by dissuading their citizens from having recourse to surrogacy. This is the only best protection of the child, the only best protection of human rights. Thank you very much.